This is our last case that we will hear this morning before we take a short break. It is Rowland versus Independence Village of Oxford. It's a 15-minute mini oral argument on the application. Mr. Granzotto, that means if you can reserve some of your 15 minutes, you can use it for rebuttal, but you'll try and do that on your own. And if you are ready, you may proceed.
Thank you. Good morning, Mark Granzotto on behalf of the plaintiff appellant in this matter. In its March 19th order scheduling this hearing, the court has asked the parties to consider three different issues. It's pretty clear that the Court of Appeals got all three of these issues wrong. The first one has been conceded as I read the defendant's response on the question of the special relationship that exists here. The defendant has acknowledged that there is, in fact, a landlord-tenant relationship between Independence Village and Ms. Kermath. That is just a subset of another type of special relationship, which is inviter-invitee. The defendant has, in their supplemental brief, indicated that the relationship between Independence Village and Kermath was that of a landlord and tenant, nothing more. That statement is correct in one sense, and that resolves the question of whether there's a special relationship. It's also incorrect because there is, in fact, something more about this case, which makes it, seems to me, even more appropriate for a special relationship determination. This is a facility that obviously markets itself to elderly people. It has a clientele which, according to the evidence in the case, consists of people who are in their mid to upper 80s. It is not just a regular tenancy that provides only a room. It also provides room and board. It also provides some amount of laundry service, things like that. It also has buttons that can be pulled in case of an emergency, and it requires check-in twice a day. This is a very different animal than a regular tenancy, but all of these other factors make this more appropriate for a special relationship, which of course requires the defendants to take affirmative acts to see that the facilities are in fact reasonably safe for their tenants.
Mr. Granzotto, let me interrupt you and see what questions folks have, and if they don't have any, you can keep going. So I'll start with Justice Clement.
No questions right now. Thank you.
Justice Cavanagh.
I don't have any questions right now.
Justice Welch.
Sure. Mr. Granzotto, so what duty precisely do you believe Independence Village did owe to the plaintiff in this matter?
Well, the duties in this case are quite limited. Obviously, the duties we're talking about are based on what's alleged in the complaint. And the complaint alleges very specific things that should have been done differently. You speak in terms of duty. It probably is better to speak of this in terms of what duties they have breached at this point, because the duties that the plaintiff has alleged in this case consist of putting some sort of monitor on these doors or putting some sort of buzzer system on these doors to notify the staff that there has in fact been an elopement. The other claims that have been made in the case, as you know, Ms. Kermath got locked outside and was incapable of getting back in. So another part of the breach in this case that plaintiff has alleged is that there should have been something, an intercom system or a doorbell, as simple as a doorbell, that should have been used in this case to allow somebody like Ms. Kermath to notify the staff. Now that becomes very important, it seems to me, in terms of the last question that this court has asked, because the last question this court has asked is the question of whether there's a common law duty. And part of that determination beyond foreseeability and relationship, part of that determination is based on the burden that would be fixed on the defendant. But the key point to be made in this case is the burden that would be fixed on the defendant is minimal. We have minor technological steps, relatively cheap as well, that could have been taken in this case that would have prevented Ms. Kermath's death. And that, to me, is a very significant aspect of this case, to be distinguished, for example, from the Williams case in this court, which was a case that really rose and fell, it seems to me, on the fact that the duty that the plaintiff was trying to impose on in that case was rather severe for the defendant. That is, to hire full-time armed guards to try to prevent third-party assaults that was involved in this case. This case must be contrasted to some case like Williams, in which that sort of burden would be imposed on the defendant. In point of fact, the burden was much smaller in this case.
Justice Welch, do you have additional questions, or you?
I am all set. Thank you so much.
Mr. Granzotto, you kind of addressed my question to Justice Welch, but I was confused by the complaint, frankly. I know you didn't write it. It seems like you took this case over from somebody else on appeal, but why aren't the specific things that might have been done to protect the plaintiff in this case, or the deceased, I should say, in this case, why aren't those questions of breach? And why are we making this so hard that the duty is to put on a bell that rings at a pitch that's like can be heard by a dog? And I don't understand why we fetishize describing a duty so specifically. Doesn't the landlord just have a duty of reasonable care, and then we determine whether that duty was breached based on the particular facts of this relationship?
You are absolutely correct in the way you've described it. Okay, the fact is that the duty that exists in this case, based on the foreseeable dangers presented, is broader. Okay, but the question that's been presented by the court and the Valkanian and in-res certified question determinations, Buskowski, this court has identified a multi-factored test to determine in those particular cases whether a duty will be recognized. I frankly am in agreement with you. I do not think you have to get to Valkanian and in-res certified question, but the defendant has suggested that that's true. And in that balancing test, there is this question of how much of a burden would be shifted to the defendant. And in that sense, that's where my complaint seems to me to be very helpful to the plaintiff, because a recognition of a duty in this case is not going to impose that great a burden on the defendants in this case. And to the extent that Buskowski and Valkanian and in-res certified question are in fact relevant to this determination, that becomes important. But I'm in agreement with you.
Okay. So would you also agree with me that this is academic, so I should probably stop wasting time, but isn't it the case that a court could find in some cases that there's no breach as a matter of law? I'm not saying in this case, that's not what I'm talking about. I feel like courts fetishize duty because they're reluctant to say there's no breach as a matter of law, but you could imagine, I could give you hypotheticals where you'd agree with me that there's no breach as a matter of law, couldn't I?
Yes, you can.
I know you're not going to like it, but I can, right?
I understand that there is something unique about the law of negligence.
No, I know all that. I'm just saying it is the case. But the
fact is that as the standard of reasonable person does in fact implicate the conscience of the community, it seems to me. And that is in fact the jury's responsibility. And that's why unlike other areas of the law that you deal with all the time, in negligence cases, you can have completely uncontradicted facts. Completely uncontradicted, everybody knows what the facts are. And still, on the question of breach, no summary disposition can be ordered, precisely because the question of what is reasonable in the circumstances belongs to the jury. But you are again correct. There are rare cases in which breach is, in fact, something that could be decided by the trier of fact.
Okay, that's all I wanted you to admit. Thank you very much. Justice Zahra.
No questions, thank you.
Justice Viviano.
On this issue of a special relationship, doesn't that have something to do with the extent of the duty that's owed?
I'm sorry, could you repeat that?
This idea of the special relationship, which I think the Court of Appeals basically recognized here, the landlord-tenant relationship, but doesn't that have something to do with the extent of the duty that's owed?
Well, I don't really think so. I mean, in the sense that the recognition of a special relationship does in fact add something to negligence law that doesn't exist usually. Your opinion in school, I think, summarized this law pretty well. That's why I cited it. The fact is that normally in negligence law, there is no duty to affirmatively act, but there is unquestionably a duty to affirmatively act, to protect, to aid, whatever you want to say, when you have a special relationship. And we do have a special relationship here. Whether you want to call it landlord-tenant or inviter-invitee, there is such. So that is an added duty if you want to.
Aren't you trying to create now a subclass of special relationships here in this case for elderly tenants?
The point is, I don't have to make a new Michigan law with respect to elderly tenants. My only point with respect to the type of clientele that this defendant has is that there is all the more reason to recognize an affirmative duty to act to protect these people. They have.
Not that I would charge my father rent, but my dad's 86. So if he came to my house and I rented a room to him, would I then have to have 24/7 monitoring at my house because he's my tenant and we have a special relationship? Not as special as, father-son, but a special relationship nonetheless.
Well, I don't know if your relationship with your father is such that the law would classify it as a landlord-tenant or inviter-invitee. Let's say that you in fact charged him money to do this. You would in fact have placed yourself, it seems to me, under the auspices of what the Michigan law has recognized without exception as a special relationship. So the answer to your question is, depending on how you manage this relationship with your father, you would be in a special relationship. But all that would require is a duty of affirmative conduct. You would, in fact, could be found responsible in tort for the failure to act. I haven't seen
to act to do what? To protect against what? Hazards that I know about? Unreasonable hazards that I'm aware of?
Well, let me put it this way. When you invite your father over for dinner, I assume he is a licensee. Under Michigan law, you have obligations, whether you know it or not, as a person who has a licensee on his property. So to the extent that that's true, if you invite him over and make him pay for room and board, you are probably in the category of an inviter-invitee, in which case you have all of the affirmative obligations, which I'm sure you know quite well, that exist for an inviter-invitee.
But is monitoring that person in the way that you're suggesting in this case? Is that one of the traditional duties?
Well, we're not talking about monitoring people here. This is something that's important here. We're talking about monitoring doors and exits. That's important. The obligation that exists in this case is to put a buzzer to let people know that somebody is going out a door. That's not a monitoring.
You'd have to have somebody who monitored the buzzer, or else the buzzer would just make noise, right? And well, somebody would have to respond to the buzzer, wouldn't they?
There are some things called alarms, and there are alarms that could notify people that somebody has left the premises. And I should think, I haven't priced them, mind you, that's not exactly a serious burden that's been put on people.
Does the lease in this case, I thought I saw some reference to the notion that the lease said that the landlord was not going to monitor the doors. Is that true?
The lease can say whatever it wants to say. The lease can say whatever it wants to say. The common law has something to say about this relationship. And that's what's at issue in this case. A common law has something to say.
So people can't freely contract for a lesser level of supervision. The common law and what you're saying says they have to do all these things. That's why I sort of got to my question. If I have one tenant, I have to do the same thing. I have to put an alarm on the doors, and I have to have someone available to respond to that alarm if I have one tenant who's elderly.
We're getting into this question of whether in fact you've been negligent in what you're doing. But the fact is, if you have one tenant and that one tenant is exhibiting and he's paying, He's paying. So you are an invitor, invitee, landlord, tenant, whatever you want to call it. And that person is exhibiting cognitive decline such that they're wandering around and going to leave the premises, then I would suggest that you do, in fact, have a common law duty to make sure that that there are systems in place that prevent that person from leaving the premises.
Whether that person wants that level of attention or care or supervision or not, we should all charge older people more money as tenants because they're entitled to it.
You know, it's funny because I think the plaintiffs in this case is in fact paying a premium for this this particular place of abode. They're paying for a premium because they get 2 meals a day. They're paying for a premium because they get laundry. Okay, but the point of this whole thing regarding a special relationship is they are this entity is responsible for the same level of action as any other landlord or tenant. The point of this case is they're to be treated no differently than any other landlord. And that is, they have responsibility for the safety of the common areas. We're not talking about her apartment. This is standard law in Michigan that exists for the common areas of a leasehold. Nothing is different. Now, whether that applies to your house and your father, if he's paying, I can't tell you off the top of my head. But with respect to a landlord-tenant relationship, okay, there is no question that landlord, and the defendant has conceded this fact, there is a landlord-tenant relationship. That landlord has an obligation with respect to the safety, the reasonable safety associated with the common areas of the leasehold.
So why does the case have anything to do with the age of the tenant then?
It has, I will tell you this, it has nothing to do with the age of the tenant. The age of the tenants represents, and what this company operates and how this company markets itself is only a factor in my mind because it enhances the obligation to recognize a special relationship. You need not go beyond landlord-tenant, invitor, invitee. It is not necessary. But the fact
does every landlord then have a duty to have an alarm on the doors in the wintertime and someone to monitor that alarm?
I would suggest to you that no, that is not true. And that is, it seems to me, where foreseeability comes into play, something I haven't had an opportunity to address here. But yes, once you have foreseeability, I'm sorry.
So I'll let you move on to another.
No, I'm out of time.
Yeah.
You're not quite out of time because I think Justice Cavanagh has a question.
Okay, I'm sorry.
Thank you. I guess it's just a restatement of what Justice Welch was asking. But if you were writing the opinion for us, or looking at it another way, like what would a jury instruction say that defendant has a duty to what?
Well, I don't know if I like putting duty in terms of a jury instruction, because I do not think it's necessarily a jury question. But the defendant has, if you're going to describe it, the defendant has a duty of due care with respect to foreseeable risks associated with the common areas of the leasehold. That is the generic description I would have. And in saying that, giving that generic description, I have created no new Michigan law.
Okay, thank you.
Thank you.
Thank you, Mr. Granzotto. Now you are way over time. Ms. Waske.
Thank you, Madam Chief Justice. Good morning. May it please this court, Amanda Waske on behalf of defendants FLEs in this matter, collectively referred to as Independence Village. The issues before this court have been extensively briefed, and so it's my intention to keep my remarks relatively short. We see the issues in this matter really boil down to whether, when considering all the factual circumstances of this case, with a particular focus on the relationship between the parties, the risk of the decedent's injuries were not objectively foreseeable to Independence Village. On a broader scale, the issue has been framed about whether or not a special relationship does exist to impose a duty by independent senior living facilities, not nursing homes, not other types of care facilities, but independent senior living facilities and its tenants. And it's our position that the answer to both of those questions is no. Independence Village was not at the time, and it is not now subject to any special licensing requirements. It's essentially an apartment community for adults age 55 and older who wish to live independently while in a community setting. The relationship between that parties, again, it's a relationship between the landlord and the tenant, and that's it. And what is inherent in that relationship and between these parties is the presumption that the tenants of Independence Village are capable of living independently. Tenants of this facility do not entrust themselves to the control of Independence Village, nor do they rely on Independence Village for their protection or for their supervision. The lease agreement is clear that Independence Village does not provide any personal care services, and further, it disclaims any promises or representations relating to any security measures. Here, Independence Village must have been able to foresee that Ms. Kermath's injuries could arise from the mechanism which they resulted from. The mechanism of those injuries is her risk of elopement due to cognitive decline associated with her age and her battle with dementia. However, knowledge is the key to foreseeability. And when we look at all the factual circumstances of this particular case, no one had noticed that Ms. Kermath was at risk for elopement. Not her daughter, not her son, not the third-party caregiver hired by the family to provide care services for her, least of all Independence Village. Where the three people closest to Ms. Kermath could not predict her elopement, that risk was certainly not foreseeable to Independence Village. The facts surrounding Ms. Kermath's death undeniably are heartbreaking. Unfortunate facts, however, do not make the injuries suffered by Ms. Kermath any more foreseeable, and without foreseeability, there can be no duty at common law or otherwise. Without a duty, plaintiff cannot succeed on her negligence claim. Additionally, the imposition or recognition of a special relationship giving rise to any heightened duty requires that Ms. Kermath required control over herself and over her safety, and those facts just do not exist in this case. So it's our position that the Court of Appeals decision was correct. There's no grounds to review this case under MCR 7.305B, and we ask this court to deny the application for leave to appeal. And with that, I'm happy to take any questions.
Thank you, counsel. I'll start with Justice Clement.
No questions. Thank you.
Justice Cavanagh.
I guess can you respond to what Mr. Granzotto said there at the end of how he would describe the duty? Do you agree that that Independence Village has a duty to use due care with respect to the common areas of the property that they lease?
Yes, to keep common areas reasonably safe. And I don't believe that there was a breach of that duty. The door which Ms. Kermath exited out of locked behind her. That in and of itself is a security measure to prevent third parties from getting into the building. She had keys to that door. She had keys to her apartment. She had keys to the mailbox.
Okay. I appreciate your position. So you agree there's a duty. You think that there is no question of fact as to whether or not your client breached that duty.
Correct.
But there is a duty, and there's no question of fact on breach. Obviously, Mr. Granzotto thinks otherwise, or that at least a jury should make that decision.
I would agree that there is a duty between a landlord and a tenant, and that's it. There's no heightened level.
But the duty that he just said is not a new duty or a heightened duty. It's a duty to use due care.
Correct.
To keep common areas, to provide a safe common area for the tenant.
Correct. Yes.
Okay. All right. Thank you.
Thank you.
Justice Welch.
No questions.
Thank you.
Counsel, following up on Justice Kavanaugh's question, it sounds to me that your argument today is different from what the Court of Appeals held. But you're saying kind of what I was pushing Mr. Granzotto on, not in this particular case. I just was trying to talk about it as an academic matter, that it is possible for a court to say that there's no breach as a matter of law. In this case, I think you're also saying there's no disputed facts about the particular breach here, right? Everybody kind of agrees about what the facts are. And your view is, based on those facts, there is no jury question about whether the safety precautions that the plaintiff thinks should have been taken were necessary. You both think there's no question of fact, and the facts as presented mean there's no triable question on breach. Is that fair?
That's fair.
Yeah. Okay. Thank you. Justice Zahra?
No questions.
Justice Viviano?
No questions.
Are there any additional questions for Ms. Waske? Or do you have any other argument you would like to make, Ms. Waske? You have a lot of time.
No, that's it. Like I said, these issues have been pretty extensively briefed. And so we're content with how, we've represented our position in our briefing.
Thank you very much for your presentation. Thank you, Mr. Granzotto. The case will be submitted.